I have 12 o'clock on my clock here, so we'll go ahead and get started. We are delighted to have today our CLE on the Minnesota State Supreme Court update of cases from last year. We're joined by attorneys from the Attorney General's office. Before we dive right in, I just want to remind everyone that we are recording this session, so please keep your microphones muted and your cameras off. If you have questions, you can enter them in the chat. We will try to have some time at the end to get to those, so please do leave those in the chat if you have them. And with that, I will turn it over to Liz Kramer.
Wonderful. Thank you so much, Sarah, and thanks to the State Law Library for inviting us and for putting on such great CLEs all the time. I want to start by just giving you an overview of what you can expect today. We're going to take you at breakneck speed through what we decided are the major decisions from the Minnesota Supreme Court in 2021. We took a look at all of their decisions and broke them into 5 categories. They are criminal, environmental and energy, pleading standards, employment law, and then kind of a constitutional and other grab bag. And as Sarah said, hopefully we'll have time for questions at end. But before we get started with those substantive areas, I want to introduce you just first to a big picture of the court. Ed, if you go forward, I think 2 slides. So in 2021, the court issued 81 opinions, which as you'll see is down a bit from the previous year where there were 96. A lot of those 81 opinions were kind of public law opinions. The Attorney General's office was involved in 17 of those, whereas I count about 11 from the year before. And 34 of the 81 were criminal cases, which again is a higher proportion than usual. You might expect that that's just because public law cases were some of the few during the pandemic that really could proceed and make their way through the judicial system. Of those 81 opinions, 15 had dissents, which is a lower proportion of cases than in the previous year. So, you know, is this Justice Moore being on the court for his first full year? Maybe he's, you know, kind of magic in terms of getting folks to agree. And I see something in the chat that someone can't hear me. Sarah, I assume you will let me know if others are having problems. In terms of staying those dissents for a moment, it's the Chief Justice who dissented most often. And then for those of you who haven't had a chance to appear at the Minnesota Supreme Court in a while, during the pandemic, they switched to a system where there was 1 3-minute opening by the advocate without any interruption. And then they cut you off immediately and start taking questions. So a little bit of different procedure. So now we're ready to get into the meat of some of those 5 categories of cases. And before we do that, I'd like to just tell you who you'll be hearing from. Of course, all of your presenters deserve much longer introductions, but we don't have time for that. So I'll tell you, they're all amazing appellate advocates. They've all clerked for fantastic judges. And you will hear from Ed Stockmeyer, who's an Assistant Attorney General who handles criminal appeals. You'll hear from Pete Farrell, who's an Assistant Attorney General in our environmental law group. You will hear from Angie Behrens, who's a manager of our administrative law division, and Cicely Miltich, who recently transitioned to Lathrop GPM, where she does employment law. And you'll hear from me. I'm Liz Kramer. I'm your state solicitor general. So with that, I will pass the baton to Ed Stockmeyer to talk about criminal law.
Thanks, Liz. Like Liz said, I'm going to be touching on the criminal law decisions from last year, and I'm going to jump right in because we do not have much time to get through everything. So the first case I want to talk about was the court's only Fourth Amendment decision from last year. It's State versus Taylor, and it's a traffic stop case. So the facts of the case are that the officer saw during a routine traffic stop, an officer saw an open case of beer in the back of the car. It was missing some cans, but there weren't any empty cans in the car. The officer queried the driver's name and learned that the driver's license was canceled as inimical to public safety, which is a type of license cancellation that usually results from a lengthy history of impaired driving incidents. However, when the officer spoke with the driver, he didn't actually observe any outward symptoms of actual alcohol impairment. So the issue in the case was, were those minimal facts, the open beer case and the status of the driver's license, sufficient to create a reasonable suspicion that this driver may be driving while impaired? The majority decision, authored by Justice Chudich, held that there was reasonable suspicion to expand this traffic stop into a DWI investigation. The majority emphasized that reasonable suspicion is a low standard. In my opinion, it's among the lowest that we see in criminal law, and that it's really about the combination of the canceled license and the missing beers that were sufficient to at least provide an objective basis for suspecting that this driver might be impaired by alcohol. The dissent, authored by Justice Thiessen and joined in part by Justice Anderson, really just disagreed with the strength of the inferences that the majority was drawing. And the dissent emphasized that those inferences have to be taken in light of the fact that this driver actually didn't appear to be impaired when the officer interacted with him. The reason that I wanted to flag this decision is a portion of Justice Thiessen's dissent that was not joined by Justice Anderson. And in essence, Justice Thiessen argues at some length that our Fourth Amendment jurisprudence, and in particular our rules for traffic stops and other interactions involving reasonable suspicion, should be calibrated to address or account for the inequities that we find in our criminal system. So I think it was a really interesting dissent. I recommend everybody read it, particularly if you're practicing in criminal law. These are arguments that everyone should be familiar with. So the next batch of cases that I want to talk about have to do with statutory interpretation of criminal statutes. And a common theme that we saw in we'll see in the two cases I've selected, but it's a common theme we've seen for a number of years from this court now, is that the court is not going to be swayed by arguments about what the criminal law should be or what the criminal law was intended to be if the statutory language or existing precedent are clear about what the criminal law actually is. So the first statutory interpretation case I'd like to touch on is State versus Khalil. It's a sexual assault case involving a victim who was unconscious at the time of the assault due to alcohol consumption. The defendant was found guilty of third-degree criminal sexual conduct, which requires proof that he knew the victim was mentally incapacitated or physically helpless. And on appeal, he argued that the state didn't prove that he knew the victim was mentally incapacitated. So mentally incapacitated is a term that is defined in Minnesota law. It means lacking judgment to consent due to the influence of alcohol, a narcotic, anesthetic, or any other substance administered to that person without the person's agreement. So note the final clause of that statute is all about involuntary administration. And the defendant argued in his appeal that the evidence showed that the victim had voluntarily consumed the alcohol in this case, and that's why the evidence was sufficient. The state argued on appeal that that language about involuntary administration only actually modified the clause referring to any other substance, and that it didn't reach all the way back to affect the reference to alcohol in the definition of mental incapacitation. The Minnesota Supreme Court rejected the state's textual argument and held that the evidence was sufficient or insufficient because a person under the influence of alcohol is not mentally incapacitated unless the alcohol was involuntarily administered. And the court held that was plain from the text of the definition of mental incapacitation. You may recall about a year ago, this decision generated a pretty significant amount of local publicity. And during special session over the summer, the legislature enacted a number of amendments to the state's criminal sexual conduct statutes, including redefining mental incapacitation so that it now includes voluntary intoxication that renders a person unable to consent. The second case I wanted to talk about was State versus Noor. I'm assuming most people are pretty familiar with this case, but Mohammed Noor fired his gun at Justine Ruszczyk while responding to a routine 911 call, which tragically caused her death. He was acquitted of second-degree murder, but he was found guilty of third-degree depraved mind murder, and on appeal, he challenged the sufficiency of that conviction. He had a lesser manslaughter conviction that he did not challenge on appeal. So the statute regarding third-degree depraved mind murder prohibits causing another's death without intent by perpetrating an act eminently dangerous to others that evinces a depraved mind without regard to human life. So the Minnesota Supreme Court in a unanimous decision held that depraved mind requires the defendant to exhibit indifference to human life in general and does not apply to conduct that is directed with particularity at the victim. So the court held that the evidence in this case was insufficient to prove depraved mind murder because when Mohammed Noor pointed his gun at Ms. Ruszczyk and intentionally fired it, he wasn't acting with indifference to human life in general. He was directing his conduct at a particular person. I think it's fair to ask in light of this decision, well, what exactly is depraved mind murder if shooting somebody isn't depraved mind murder? And the court provided some helpful examples in the opinion of what depraved mind murder looks like. The most helpful is driving a car into a crowd of people. You can see in that example that the perpetrator is exhibiting indifference to everybody around him and is not necessarily targeting any one particular person. The final batch of decisions that I want to talk about have to do with retroactivity in criminal appeals and post-conviction litigation. So the first case is State versus Robinette. It's actually not a retroactivity case. It's about a related doctrine called the Amelioration Doctrine that is unique to criminal sentencing. And the Amelioration Doctrine holds that changes to sentencing rules apply to sentences that were imposed before the effective date of the new rule if three elements are met. First, that the new sentencing rule mitigates punishment. So changes to the law that would actually increase punishment don't trigger this doctrine. Second, the judgment was not final on the effective date. So in the language of retroactivity, we're talking about pending cases here. And third, the legislature did not expressly abrogate the Amelioration Doctrine. What I want to emphasize about the Amelioration Doctrine is the third element is the most important. That's the element that there's going to be the most litigation under. And it's really a clear statement rule. The Amelioration Doctrine is going to apply unless the legislature clearly states that it should not apply. So the facts in Robinette are that new sentencing guidelines took effect while the direct appeal was pending, and the defendant filed a brief asking to be resentenced under one of those new rules. The problem for the defendant was that the Sentencing Guidelines Commission, when it enacted or put forward the new guidelines, clearly stated that they should be have prospective effect only, and that the Amelioration Doctrine should not apply. So this is actually a pretty express abrogation of the Amelioration Doctrine. So the issue on appeal was whether the Sentencing Guidelines Commission, rather than the legislature, actually has the authority to abrogate the Amelioration Doctrine in that manner. The majority held in a 6-1 decision that abrogation must be a statement by the legislature. In other words, a statute and legislation. Statements by the Sentencing Guidelines Commission cannot abrogate the ameliorative effect of sentencing guidelines. So the take home from that is that the defendant was allowed to get resentenced under the new rule. The dissent authored by the Chief Justice disagreed with that conclusion, but the Chief Justice raised sort of a logically prior or threshold issue. And that is that the court had only ever applied the Amelioration Doctrine to new sentencing statutes. It hadn't actually ever applied the doctrine to new sentencing guidelines. And so the Chief Justice argued that we shouldn't even be talking about this doctrine in this context because the new sentencing rule wasn't a new sentencing statute. This was a sentencing guideline. The majority noted that the parties hadn't properly preserved that issue, and so the court didn't need to address it in this case and reserve that issue for another day. So that's going to be the big issue in the next couple of years on the Amelioration Doctrine, whether this doctrine should apply only to new sentencing legislation or whether it should apply to other sorts of sentencing rules. There were two other retroactivity decisions last year. I don't really have time to get into either of them in some detail. Johnson versus State is just about whether a prior decision from the US Supreme Court was retroactive or not, and the court held that it was retroactive. And Ailey versus State is about the statute of limitations in post-conviction cases where the defendant is seeking relief for a retroactive rule and when the statute of limitations begins to run. But again, I don't have time to get into those cases, so I will just pass things off to my colleague, Pete.
Thanks, Ed. I'm going to cover the cases that fall into the environmental and energy bucket from the Minnesota Supreme Court from this year. And I want to start off with some general observations. I pulled together some statistics. 2021 was a busy year for the court's environmental and energy docket, and it follows on a busy 2020, which contrasts with a dearth of cases in the period from 2016 through 2019. A couple caveats on these statistics. I think it's always difficult to categorize cases. So my criteria were, did the case involve one of the major regulatory agencies in Minnesota? Did the case involve a major environmental statute? And using that criteria, you can definitely see an uptick in the number of cases the court is taking. So that raises the issue, is this part of a trend? Next slide. And I think it really depends. On the one hand, there are several large controversial projects in Minnesota that are either proposed or completed, nearing completion, that have generated a lot of environmental litigation, particularly in the mining area. I also think it's fair to say that if you're looking at the cases the court is deciding in the environmental and energy area, a lot of the expanded docket seems to be driven by more mundane administrative law and statutory and regulatory interpretation issues. I do think since we originally gave this presentation in December of 2021, there is another data point in favor of a trend. The court did grant at the end of 2021 in an important case involving the classification of public waters. That case was argued on April 11th, and so a decision is likely to issue this year. Definitely something to keep an eye on. So with that background, I'm going to dive into the cases and focus on the four cases that I think are most important from this past term. And the first one has the snappy title of In Re Reissuance of a NIPD's SDS permit to US Steel Corp. And this case is about whether groundwater is a Class 1 water under Minnesota law. And the reason that matters is if groundwater does qualify as a Class 1 water, then it can potentially be subject to these more stringent drinking water standards that are promulgated by the Federal Environmental Protection Agency. And then the State Pollution Control Agency can use those standards in water pollution permits that it issues. And that's exactly what the MPCA did here. One of the permitted issue relates to US Steel's Mintac mining operation in Mountain Iron, Minnesota. And MPCA issued a permit that imposed a groundwater sulfate limit. US Steel challenged that limit, and US Steel's basic argument was nowhere in the applicable regulations do they say that groundwater is a Class 1 water. The Court of Appeals agreed with US Steel, but the Minnesota Supreme Court reversed. It held that groundwater does qualify as a Class 1 water, and therefore it could be regulated under these more stringent drinking water standards. Now, I think the main takeaway for practitioners from this case is really, it stands as a strong reaffirmation of the principles of agency deference. In Justice Thiessen's decision, he really emphasized that if a regulation is ambiguous, the agency's interpretation is entitled to considerable deference, particularly when you have certain criteria. Those criteria would include whether the regulation involves the agency's technical expertise, whether it's a long-standing interpretation, and whether the administrative history supports the agency's interpretation. Contrast the decision in U.S. Steel with some decisions that are coming out of the United States Supreme Court, where some of these agency deference doctrines seem to be on thin ice. We're not really seeing the same thing at the Minnesota Supreme Court in the context of state regulations. The next case I'm going to cover has to do with the proposed copper nickel mine, the Polymet mine in northern Minnesota. There's a number of different pieces of litigation arising from that project. This particular decision arose from the DNR's decision to issue a permit to mine to Polymet. That's the main permit you need in Minnesota to operate a mine. And it was subject to a number of challenges. I'm going to focus really on one here. The first is whether the existence of a fact dispute requires the DNR to hold a contested case hearing on a permit to mine. Now, that matters because a contested case hearing is effectively a trial-like proceeding at the Office of Administrative Hearings. And the Court of Appeals had held that under the relevant statute, if an environmental group or some party challenging the permitting decision came forward with probative, competent, and conflicting evidence, then the DNR was required to hold a contested case hearing, required to essentially hold a trial on various aspects of the permit. This could have really reverberated throughout Minnesota in terms of how permitting was done. It could have required a lot more of these trial-like proceedings before permits could be issued, particularly with respect to major projects where it can often be the case that a fact dispute can be identified by a party who's challenging the permit. The secondary issue I'll just flag is the DNR had determined that the permit to mine was going to be issued with a performance-based term, not a fixed term. And the reason the DNR did that is it's difficult to forecast in advance how long it's going to take to clean up the mine. The challengers had said, no, you need a fixed term for this permit. The Court of Appeals also agreed there with the challengers. So this went up to the Minnesota Supreme Court, and the Supreme Court held that the DNR is not required to hold a contested case hearing whenever there is a fact dispute. Again, reemphasizing that principle of agency deference, the court held that the DNR had discretion to determine whether a contested case hearing would aid the decision-making process. On the term issue, the court agreed with the Court of Appeals, held that even if this makes sense from a policy perspective, term means term, and that's a fixed term of years. So I think the key takeaways from this case for practitioners are environmental agencies, expert agencies are going to get a lot of deference in their permitting decisions, but they still need to show their work. The court here really did a thorough examination of each of the issues that the petitioners had sought a trial-like proceeding on, and looked for whether there was evidence in the record to support the DNR's decision to deny the contested case hearing request. For one of those issues, the court said that the DNR's record was insufficient. So this isn't toothless review, even if it is deferential to the agency. I also think this case is worth flagging because it contains a very useful synthesis of the substantial evidence standard, which there's a lot of different formulations in the case law. I think this is going to be one that you see cited a lot. I know the attorneys in my division are already using it because it really captures what the substantial evidence standard is. So the next case I want to talk about arises from the state's Public Utilities Commission, and it involves the PUC and the state's flagship environmental law, the Minnesota Environmental Policy Act, which governs environmental review in Minnesota. A little bit of context here. This case arose from Minnesota Power's proposal to partner with Dairyland Cooperative, which is a Wisconsin co-op, to build a natural gas power plant just across the border in Superior, Wisconsin. Now, under Wisconsin law, a foreign entity cannot own or operate a power plant. So Minnesota Power has to, operate, construct this facility through a Wisconsin affiliate. That's where the state PUC comes in. It has regulatory jurisdiction over the affiliate interest agreement that Minnesota Power entered into with its Wisconsin affiliate related to this deal. The issue in this case was whether the PUC had to conduct environmental review before it approved that affiliated interest agreement. And the reason this case mattered, the real legal issue posed by it is, what is the causation standard for environmental review under MEPA? Is it but for, or is it something more than that? The Court of Appeals had held that, sure, while this facility is going to be built in Wisconsin and Minnesota doesn't have ultimate regulatory authority over it, the decision from the PUC was still part of the causal chain that would lead to the facility being built, and therefore that was enough to trigger the requirement for environmental review. The Minnesota Supreme Court said no. They held that the PUC is not required to conduct environmental review before approving this type of agreement. The court adopted the federal causation standard, and under that standard, there needs to be a reasonably close causal relationship between the environmental effect and the alleged government action at issue. And here, that standard wasn't met because the connection was just too attenuated. In essence, the Wisconsin facility could be built and run without PUC approval. Now, as a practical matter, maybe that wouldn't have happened. Minnesota Power was a very important partner here, but as a legal matter, that was the case. And so the court said there was no requirement for environmental review. The last case that I'm going to touch on is State by Smart Growth Minneapolis versus the City of Minneapolis. And this is a case that arose out of Minneapolis's decision to adopt its comprehensive plan for 2040. This plan generated some controversy because it essentially provides, this is a simplification, but it provides for and requires more dense zoning within the city. And that could potentially have some adverse environmental effects. Now, the wrinkle here is comprehensive plans under the state's environmental review statute and its implementing regulations, the Minnesota Environmental Policy Act, MEPA, are exempt from environmental review. The environmental group here said, okay, that's fine. Well, we're going to sue under a different environmental statute, the Minnesota Environmental Rights Act, or MIRA. There's a lot of alphabet soup in this area, but MIRA is the vehicle that the plaintiffs use to try to get environmental review, even though that's prohibited under MEPA. So that was the main issue in this case. There was a secondary issue of whether the plaintiff states a claim under MIRA if the comprehensive plan by itself doesn't cause any environmental effects, because the comprehensive plan is really a planning document. It doesn't actually implement any decisions on the ground. So the issue here is really, is MIRA a workaround from the comprehensive plan exemption under MEPA? The Minnesota Supreme Court said yes. A plaintiff can challenge a comprehensive plan and seek environmental review as a remedy under MIRA. This is the second time in 2 years. There was another decision arising from basically some litigation over White Bear Lake in 2020 under MIRA, where the court has really emphasized the broad scope of this statute. MIRA effectively provides a civil remedy to anyone in the state to sue to prevent pollution or adverse impacts on environmental resources. And the court emphasized that unless something is specifically exempt from the broad scope of MIRA, absent express statutory language that says that, they're going to assume you can bring a MIRA claim. And so they allowed the suit to go forward. On the secondary issue, whether the plaintiffs had failed to state a claim, the court held that they had done enough. They essentially held that, under the Walsh pleading standard, the plaintiffs had alleged sufficient facts to show that even though the planning document didn't make any sort of specific implementation decisions, the facts alleged showed that there could be a causal effect between adopting the plan and environmental effects. And so that was sufficient to state a MIRA claim. again, I think this is, my colleague Angie will talk about this in just a moment, but this is another example of the court emphasizing that in Minnesota, the pleading standard is Walsh, and the court is going to look at the pleading really in the most favorable light to the party who has filed the complaint. So with that, I will kick it over to Angie.
Thanks, Pete. So overall in 2021, the court issued 16 decisions in cases that arose from a dispositive motion under either Rule 12 or Rule 56. And in the majority of these cases, the court reversed on at least one issue. And the court didn't really break any new ground in terms of what the pleading standards are, but it did offer some helpful guidance and some reminders in terms of how those standards of review should be applied depending on whether we are at the complaint stage or the summary judgment stage. So as far as some big picture themes, the court reaffirmed, as Pete just noted, we are a notice pleading state in Minnesota. We do not follow the Iqbal Twombly plausibility standard that applies in federal cases. The court first told us that in Walsh in 2014, and it reminded us of that several times last year. And the standard of review on the screen there should be quite familiar to everyone, but the court really emphasized that standard of review and disentangling the procedural posture and really paying attention to where we are and what stage of the pleadings when evaluating the sufficiency of a claim. So if we go to the next slide, turning to notice pleading, there were 3 cases in which the court addressed that standard in more depth. In Halva, that was a challenge under the Data Practices Act and the Official Records Act. Smart Growth, you just heard Pete talk about that. That was a challenge to the plan under MIRA. And in Werlich, that was a Section 1983 claim against the Commissioner of Corrections and the BCA superintendent, where an inmate challenged the constitutionality of having to register as a predatory offender, as well as a bunch of collateral consequences that he alleged would stem from that registration. And in each of these cases, the district court dismissed the complaint, the Court of Appeals affirmed, and the Supreme Court reversed on at least one issue. And from these cases, we can see some themes developing from what it means to state a claim for notice pleading in Minnesota. And in short, the court repeatedly tells us that Rule 8 means what it says. All we need is a short and plain statement showing entitlement to relief. We do not need a full treatise or every possible detail that could possibly support the complaint or the allegations. And the court emphasizes that the real hallmarks in evaluating the complaint are fair notice to the other side and sufficiency of the allegations. And as I mentioned, not losing sight of that procedural posture. So at the stage of the complaint, the key consideration is the plaintiff putting the defendant on fair notice of the allegations against it? And is there any possible evidence that could support the allegations alleged? It's not about proving it up now in the complaint or about proving it up later. So in Smart Growth, the case Pete just discussed there, again, the district court and the Court of Appeals had gotten into MIRA's burden shifting analysis and concluded that the complaint didn't establish the prima facie case. And the Supreme Court said, nope, that's not appropriate at this stage. You don't have to prove up the prima facie complaint or case within the complaint. It was enough that the plaintiff had alleged a protectable interest and the pollution, destruction, or impairment of that interest. Halva also offered some guidance. The court acknowledged that in many cases, and I'm sure many of us defense attorneys repeatedly cite the proposition that courts do not defer to a party's labels and conclusions. The court emphasized that that is about legal conclusions, not factual ones. And then if we could turn to the next slide, Halva also gave some guidance about pleading damages. In this case, the parties had a bit of a protracted history, and an administrative law judge had actually found a data practices violation based on the same facts that were the basis for the district court action. So the complaint in this case had walked through that history and then ended with a pretty perfunctory statement of, and we've been harmed, we're entitled to damages. The court acknowledged that that was sparse, but said that was enough because, again, going back to the principle of fair notice, everyone knew what the alleged source of the harm was, and there was enough of a factual nexus there. And there again, the court acknowledged that in past decisions, you may see statements along the lines of a party not being able to recover damages that are speculative or remote in nature. And the court emphasized that that is a trial standard. So that can be considered at summary judgment, but that should not be the focus in evaluating the sufficiency of the allegation on a motion to dismiss. Lastly, on constitutional claims, I wanted to highlight that the Werlich decision did include the quoted language there on the screen suggesting motions to dismiss are more inappropriate if there's an alleged constitutional error. But at the same time, that court interpreted the complaint very broadly, almost to be a kitchen sink type complaint, and yet it still affirmed the dismissal of nearly every single claim. The claims that survived were those that involved the plaintiff had alleged interference with his fundamental right to parent. And the majority said it was enough that he alleged he has a child, so there should be a reasonable inference that he intended to parent that child when he was released from prison. The dissent, Justice Anderson, joined by the Chief Justice, would not have made that inference because he did not allege he had any rights to the child. And as a postscript to that case, the dissenters were quite prescient because soon after the reversal, the plaintiff dismissed his surviving claims because he had no parental rights to the child he had touted within the complaint. And then lastly, in terms of motions to dismiss, I just wanted to highlight there is still, despite some of these reversals, there is still plenty of room for a proper motion to dismiss, and they still play a significant role in litigation. As I noted in Werlich, the court affirmed the dismissal of nearly all of the constitutional claims because they just weren't based on a proper legal theory or legal arguments. Similarly with statutory interpretation. In Halva, the court affirmed the dismissal of the Official Records Act claim because there was no private right of action under the Official Records Act. So still plenty of room for motions to dismiss, but just be very careful in scrutinizing how you are treating facts on a motion to dismiss. Then if we could turn to summary judgment, I wanted to highlight one case that addressed this standard in a bit more detail. Staub was a wrongful death action that arose after a woman fell down some stairs at a resort and unfortunately died. And the key dispute or fight in this case was that nobody actually saw her fall. So they didn't see what started the fall. There were competing expert reports about the condition of the stairs, but no one saw her fall. So the district court entered summary judgment for the resort, and it said because nobody saw her fall, a jury would inherently have to speculate about causation, so that would be inappropriate to proceed to trial. The Court of Appeals affirmed on similar grounds, and the Supreme Court reversed. And in doing so, it offered some helpful reminders about evidence at the summary judgment stage. And the first point there should be familiar. Of course, when reasonable people can reach different conclusions, summary judgment's inappropriate. But in Staub, the court reminds us that circumstantial evidence is evidence. So direct eyewitness testimony was not necessary to establish proximate cause. The court also discussed in a bit of detail the Majerus decision cited there, where the court reached a similar conclusion. And at the same time, circumstantial evidence, it can't just be hunches or whims. There has to be something that a jury could actually hook on to make the reasonable inference to establish the proximate cause element. So the court gives us a bit of a test to work with for circumstantial evidence. Essentially, if there are competing theories of proximate cause, we could move to the next slide, please. When there's multiple theories, then you look at the consistency between the plaintiff's and the defendant's theories. And if they're inconsistent theories, then the plaintiff's theory has to reasonably preponderate over the other theories to survive summary judgment. If the theories are consistent, then summary judgment's inappropriate because we're in familiar territory where reasonable fact finders could reach different conclusions based on the evidence. And on this record, the majority reversed and held summary judgment was inappropriate. They held that the majority held that the plaintiff's theories were consistent with alternative theories. And it also noted that there was no other reasonable circumstantial explanations of causation that preponderated over hers. The district court and the defendant in this case had offered some various theories in terms of maybe she was dehydrated because it was a hot day and she was drinking coffee. Maybe she'd been startled by an animal, or she simply lost her balance, bending over to pick something up, or perhaps she was distracted on her cell phone. And the majority here said, these are all speculations. Here's what we know. We have evidence of dangerous conditions and some circumstances around the fall. She had previously complained about the staircase and raised concerns about it. She fell shortly after that day. So the court said with these facts and a jury's life experience and common sense, a reasonable jury could make that reasonable inference to determine causation on this record. This case also had a dissent. Again, Justice Anderson joined by the chief, and they would have affirmed based on the same grounds as the lower courts. Again, with the rationale that we know a lot of things that could have caused the fall, but we don't know what actually did. So they would have affirmed on this record. And then finally, in the last slide here, this is just a roundup of some of the other Rule 12 and 56 cases. If you are interested in further readings, these cases tended to address more of the substantive areas of law rather than the pleading standards, but they still may be worth a read if you're looking for how the court is treating these types of cases. So with that, I will pass it off to Cicely to talk about employment law.
Good afternoon, everyone. Thank you so much for joining us today. As Angie said, I will be giving a brief highlight of some of the employment law decisions that came out of the court in 2021. If I could get the next slide, thanks. So these are just a couple very high level takeaways from reading the court's jurisprudence in the employment space in 2021. Of course, with any type of analysis of this type of court, there are going to be exceptions, but these are just some broad brushstrokes to take away as you're thinking about litigating your employment cases. First of all, just in general, it's a good time to be an employee. We are seeing more employee cases getting past the Rule 12 stage, getting past the Rule 56 stage, and ultimately getting an opportunity to have those cases heard by the trier of fact. Common sense and fairness are recurring themes that most members of the court are saying over and over again in different ways and in different types of cases. So whether you are on the employer or employee side of an employment litigation case, you're going to be wanting to think about how to frame your position in terms of common sense and fairness, because that's what the court's really going to be looking for. As Angie discussed, those pleading and proof standards that the court has been working through in a variety of cases, they're featuring prominently in the employment sphere. And again, that's just a little bit of a thumb on the scale in terms of employees getting an opportunity to have their claims be heard. And also this is, potentially just anecdotally the cases that were coming up to the court on the PFRs, but seeing more granting of review in public employer cases in general from the court last year. So the first case that I'd like to talk about in a little bit of detail is the Hall versus City of Plainview case. And this was a case where the employee sued the City of Plainview after it terminated him, and the city had refused to pay out his 1,778.73 hours of unused PTO. The district court had dismissed, and the Court of Appeals had affirmed that dismissal. The Minnesota Supreme Court was considering a couple issues, but the one I'm going to focus on today that I think has the broadest implications for employment law overall is whether the employer handbook that had a disclaimer had created a contract to pay out that accrued PTO to the employee. There are a couple key provisions from the employee handbook that the court was looking at. The main one that the employee was arguing created that contractual obligation stated that when an employee ends their employment with the city for any reason, 100% of the accrued unused PTO will be paid up to 500 hours unless the employee didn't give sufficient notice. In addition, in the handbook, there were two disclaimers that the employer, the city, was arguing made it so that that contractual language about the PTO did not create any contractual obligation on their part to pay out the employee. And the first, as you can see in the middle of the screen, is a longer one, which says that the manual is not intended to create an express or implied contract of employment, and it specifically retains discretion on the city's part dealing with employee discipline or termination. And it emphasizes again that the employee is at will. The second disclaimer that the court looked at was a shorter disclaimer that says that the purpose of these policies is to establish a uniform and equitable system of personnel administration for employees. They should not be construed as contract terms. So the majority took a look at these, took a look at the employment handbook and determined that it did create a unilateral contract, which, as you may remember from 1L contract class or your bar courses, is the employee says, here's our take it or leave it terms, and the employee creates that unilateral contract by accepting them and beginning to perform the requested labor. In determining that that PTO language created a unilateral contract, the majority emphasized that payment is fundamental to the employment relationship, and they equated the accrual of PTO time as one form of payment that an employee earns. And the court found that the terms of that PTO provision were sufficiently definite to create a unilateral contract, even though the city, under the employee contract or the employee handbook, retained discretion and also a unilateral right to amend. So after having determined that that PTO language created a unilateral contract, the majority then turned to look at whether these two disclaimers undid that contract, and ultimately concluded that those disclaimers were not enough to prevent the formation of a contract. Again, the majority was very concerned about the fact that this is compensation, and compensation is different than other types of employment terms. The majority specifically took a look at that longer disclaimer, and it said this doesn't really disclaim the obligation to pay out PTO. What this big disclaimer talks about is that the city retains its discretion to terminate employees and to discipline employees as it sees fit. So we don't think that disclaimer takes away the obligation with respect to PTO. And then the court looked at that second shorter disclaimer, and it found ultimately that it was ambiguous with respect to whether it applied to the PTO provision. And the majority has a very thorough analysis here of how it comes to the ambiguity conclusion. A couple things being that it was that disclaimer was general, it lacked precision, it conflicted with the more detailed PTO section, and that there were multiple alternative readings. So ultimately, the majority says that the meaning of that shorter disclaimer is going to be a question for a fact finder as to what the employee and the city meant when they entered into that contract. So a couple key takeaways, and these will kind of harken back to my first slide. Definitely an employee-friendly decision that comes out. One interesting thing, the court reached the issue despite possible easier ways out. The city had made the argument that the employee did not provide proper notice under the PTO provision. And so if the court had gone that route and determined that the employee hadn't in fact provided proper notice, they could have avoided altogether the issue of whether that PTO provision created an enforceable contract. Again, emphasis on fairness and common sense. Those specific words, fairness and common sense, appear in the majority decision. The court was really focused on what would your reasonable, typical employee expect in this situation. And the court was particularly, it seemed frustrated with the city that it was arguing that it could arbitrarily pay out PTO for some of its employees, but then it would arbitrarily decide not to for others. More disclaimers is a takeaway for people that practice in this space, and especially for people who are drafting employee handbooks. It's unclear whether more disclaimers will be effective and how effective they will be. If you take a look at the majority opinion, it's hard to envision precisely what type of disclaimer you would need in order to fall outside of the ambiguity that they found. But certainly expect to see in this space more specific disclaimers, especially around specific terms. And my personal takeaway is that we should all be using our PTO instead of fighting about the 1,700 hours that we haven't used in litigation. Let's just all take a few more vacations. The other case I'd like to touch on briefly is the Hagen versus Stephen Scott management case. This was a case where the former employee was a property manager, and she sued alleging that her employer failed to pay wages. The district court granted summary judgment and the Court of Appeals affirmed. It came up to the Minnesota Supreme Court on a couple of issues, primarily surrounding statutory interpretation under the MFLSA or equal pay for equal work law. And then also a question of whether the employer had failed to adequately pay the employee for on-call shift work. And so the court engaged in statutory interpretation. It found that rent credits do constitute wages under the MFLSA. They found that that was unambiguous. So this employee was a property manager who lived on site, and a large chunk of her compensation was a rent credit that she received from her employer. And the court did find that those wages constituted wages. But then, and the court found that they were not deductions under Minnesota statute 181.79. So basically the upshot was that the employer had properly paid the employee by giving her rent credit instead of other forms of compensation. And then the court also considered the question of whether this employee was required to be on call during various periods of time. And there were a variety of things she needed to do when she was on call. She wasn't allowed to consume alcohol. She could only be a certain proximity from the apartment building in case something came up. And so the court ultimately found that hours worked, whether those on-call hours should have been paid out, was a fact question. And so they found this provision about whether hours worked includes on-call work was ambiguous. And so, you know, again, from that case, you can kind of see the court doing a variety of different things with statutory interpretation and reaching different conclusions. But again, if you think of it from a fundamental, is this fair to the employee? The idea that she would be receiving rent credits and that those would not be considered wages, the court said, well, as a reasonable employee, you kind of expect if you're getting your rent paid that constitutes compensation. But clearly more concerned about the hours worked and whether her on-call duties were really restricting her ability to do other things during that time. Sorry, Ed, next slide now. And the last thing I'd like to leave you with, again, a couple public employee cases. And I think these two cases just set up a nice contrast that I think really highlights what the court is working through when it's thinking of the reasonable employee and what they would expect and the opportunities that employees are given. So the first case was the Reits versus City of St. Paul case. There, the city refused to indemnify a police officer who was sued as a result of work that he had done as a private security guard. The court was applying kind of the typical, as for those of you who practice in the municipal space, arbitrary, oppressive, unreasonable standard. The employee had been given multiple opportunities by the city to submit evidence in support of his claim that his work as a private security guard fell within the city's obligation to indemnify. And the court found that the employee had just not submitted evidence to meet that standard. So it ultimately upheld the municipality's decision. In contrast, in the the year 2019 salary of Freeborn County Sheriff case, the county board had set the sheriff's salary, quote, without discussion or explanation. Again, the court was applying that kind of arbitrary and capricious standard. And in that case, the sheriff had submitted detailed information about the salary that he was requesting. He'd submitted comparables from sheriff's salaries outside of Freeborn County, and the county board had basically picked a different salary. And the court found that that decision was based on whim or is devoid of articulated reasons, and reversed the county board setting of that salary. So just setting up that contrast of how many opportunities was the employee provided to present that evidence is what the county or city did there. Does it feel fair? Does it feel like they treated a reasonable employee as you would expect a reasonable employee to be treated? And with that, I will turn things over to Liz.
All right, start the video. Great. Thanks, Cicely. Now we're going to finish with a series of constitutional decisions from the Minnesota Supreme Court and a couple that fall in like a other category. So the first one is under the US Constitution, and in particular, the Second Amendment. This case is called State versus Hatch. It was a unanimous decision from our Minnesota Supreme Court, and Mr. Hatch, of course, was unhappy with that, as you'll see, petitions for certiorari at the US Supreme Court, and that was denied in January of this year. The issue presented in this case was whether Minnesota's permit to carry requirement violates that Second Amendment, and the answer was no. The permit to carry requirement comes from section 624.714, and Mr. Hatch was convicted of carrying a firearm without that permit and challenged the statute as unconstitutional. Now here, both the district court and the Court of Appeals found the statute was constitutional, right? So it disagreed with Mr. Hatch, but the Supreme Court still took review. They ducked the issue of what the appropriate level of scrutiny was, because they found that the statute passed even strict scrutiny, so there was no reason to get into whether strict or intermediate scrutiny was the appropriate standard. So applying strict scrutiny, as you all know, there's two aspects to that test, right? The first is whether the state has a compelling interest, and then the second is whether the statute is narrowly tailored. There was no fight on that first aspect of the test. The parties agreed that there's a compelling safety interest in protecting people from gun violence. The disagreement fell on the narrow tailoring aspect, but the court found the permit to carry statute is sufficiently narrowly tailored because, first, Minnesota law makes it generally easy to obtain a gun permit, and second, there's many circumstances that you don't even have to have a permit to carry a pistol. Court says, you know, you can have it in your home, you can have it in your own business, and you can have it on land that you own, all without a permit. So key holding is on your screen. It says, in short, the minimally burdensome requirements of Minnesota's firearm permitting statute are sufficiently close to the government's interest in ensuring public safety to satisfy that narrow tailoring requirement. Now, if you are in the position like I am of ever having to defend statutes based on strict scrutiny, some of the court's language on this front is really important and reminds us all that strict scrutiny is not necessarily a death knell for statutes. So it talks about, of course, strict scrutiny isn't fatal in fact. It also says that narrow tailoring doesn't require the exhaustion of every conceivable alternative, nor a dramatic sacrifice of the compelling interest. Also says that in order to be narrowly tailored, it just must not be substantially broader than necessary to achieve the government's interest. So all of these, I would say, are language which allow a little bit of wiggle room here for the government. One kind of strategic point to raise here is, why did our Supreme Court grant review of this case when it had, the lower courts had both reached the same result? Of course, I do not know the answer to that, but I think it's a useful thing to point out here, especially if those of you who are counseling clients who may have won at both lower court levels, and then our Minnesota Supreme Court grants review, you could at least point to this case along with some others to say, well, it doesn't necessarily mean they want to overrule something. Sometimes they just want to add their voices to the mix. This case is also part of a national trend on, Second Amendment litigation. There was a case at the U.S. Supreme Court, New York State Rifle and Pistol Association versus Bruin, which could change the landscape in the next couple of months, but stay tuned for that. The next case arises under the Supremacy Clause of our U.S. Constitution. And it's not actually one case, it's two cases. They're companion cases, both which have to do with the use of medical marijuana in the workers' compensation context. So Mazda versus Mendota Heights Dental Center is like the primary case here. It was a 6-1 decision authored by Justice Anderson. Again here, a petition for certiorari was filed, and that petition is still live. The U.S. Supreme Court has asked the U.S. Solicitor General for her views, and she has not yet delivered her brief on that. So maybe more to hear from this one, but the issue presented is whether the Federal Controlled Substance Act preempts Minnesota law when Minnesota law requires an employer to reimburse injured employees for the cost of medical cannabis act. And the answer then from this 6-1 majority was yes, that is preempted. Underlying story here is an employee with chronic pain after a work injury where her doctor certified her for medical cannabis use. And so that employee then properly sought reimbursement from her employer. And the Workers' Compensation Court of Appeals decided that the employer did have to offer that reimbursement. So the employer appealed. Now, I want to be clear that the parties stipulated that the employee's use of medical marijuana complied with Minnesota law and was reasonable and medically necessary for this work injury. So, you know, no kind of side concerns about whether the use of marijuana was proper here. Really just a purely legal question about whether reimbursement by the employer conflicts with the US government's declaration that marijuana is illegal. Next slide, please. So the first issue was actually an issue of jurisdiction, whether the Workers' Compensation Court of Appeals had subject matter jurisdiction to determine federal preemption, and our Supreme Court said no. That's because that appellate court is limited to legal questions that arise under workers' compensation laws. And they found that this arose under the US Constitution and preemption issues, not workers' compensation laws. So then the court went ahead and tackled that preemption issue. This is conflict preemption, where the argument was that there's a conflict between the federal law that prohibits the possession of cannabis and Minnesota statutes that require employers to furnish medical treatment reasonably necessary for work-related injuries. The employer argued that those two things were in direct conflict because it said that if it went ahead and reimbursed the employee, it would be guilty of aiding and abetting the possession of cannabis. It found two other state Supreme Courts that had agreed with that position. They had a Maine decision and a Massachusetts decision. On the other hand, the employee argued that there's no conflict between, again, the federal law prohibiting possession of cannabis and our state workers' compensation laws, because Congress has really prohibited the Department of Justice from prosecuting folks for just using marijuana in, I should say, medical marijuana consistent with state law. And they're saying by the time an employer would reimburse the employee for that medical marijuana, the crime is complete and there's no intent to aid and abet the usage. And the employee also could point to two New England states, New Hampshire and New Jersey, that had gone its way. But our Supreme Court sided with the employer here and said there really is a conflict because although those congressional dictates to the Department of Justice exist, they're temporary measures and Congress has not actually descheduled or rescheduled cannabis, right, to make it not a crime. And the court found that mens rea could be established under federal law. So you see that key holding on the screen. We conclude that mandating Mendota Heights to pay for Mazda's medical cannabis by way of a court order makes Mendota Heights criminally liable for aiding and abetting the possession of cannabis. And as it is impossible to comply with both, the court's order is preempted by federal law. So that was the conclusion on that, of course, unless the US Supreme Court decides it wants to weigh in. So moving now to our Minnesota Constitution, we have a couple of cases arise under amendments you may have never even have heard of. So there is an aircraft amendment in our Minnesota Constitution. It's in Article 10, Section 5. And this case was about interpreting that. It's Sheridan versus Commissioner of Revenue. It's a unanimous decision authored by Justice Moore, which asks whether the provision in the Minnesota Constitution about aircraft taxes precludes the sales and use tax on aircraft purchases. And the answer was no. And here on the next screen, you'll actually see the language of that aircraft provision. See, it says the legislature may tax aircraft, using the airspace overlying the state on an onerous basis than other personal property. Any such tax shall be in lieu of all other taxes. And the question here was really, what did in lieu of all other taxes mean? Because we had two plane owners, at least one of whom is a prominent attorney, who argued that the sales and use tax was unconstitutional, but they had lost at the tax court. So they brought their issue to the Minnesota Supreme Court. The court started by looking at whether the plain language of that aircraft provision was ambiguous or not. It found it was ambiguous. And then when it went about interpreting the provision, it went to a lot of different contemporaneous sources to figure out what had been the intent of the people who ratified that amendment to the Minnesota Constitution. This is important for any of us who are doing certainly constitutional interpretation, but also statutory interpretation, to think about what sources our Supreme Court is willing to look at. Here, it looked at the preamble language in the session law, the Attorney General's statement of purpose about the amendment, an article in Hennepin Lawyer, the ballot language that was used, all of which the majority found showed that the in lieu of all other taxes actually referred only to the personal property taxes that were existing at the time of that amendment. So now two cases in my grab bag section here before we finish up. One is a case that was in the news a lot before the election, Samuels versus City of Minneapolis, which was a unanimous decision authored by Chief Justice Gildame. This was the one about whether the proposed public safety ballot language was misleading, like so misleading that could be unconstitutional and not go forward on the ballots. And here, the court took this on a petition for accelerated review. So I just want to say that out loud, because before I was solicitor, I don't think I was even really aware of that appellate rule. And there are actually a number of cases that our Minnesota Supreme Court takes on petition for accelerated review. So you have that as a tool in your toolkit as an advocate. This one, of course, had to go up as quickly as possible because it dealt with ballot language and the election was right around the corner. So here, again, question presented was whether that public safety ballot language was, quote, so unreasonable and misleading as to be a palpable evasion of the constitutional requirement to submit the law to a popular vote. And the court found it was not, which disagreed with what the district court had done. Here, again, the district court had immediately enjoined a ballot language and the city had gone back and revised the language, but then even the new language was enjoined by the district court. And like I said, the Supreme Court granted that petition for accelerated review and reversed quickly in just 2 days. The point really here is that this is a very deferential standard of review. And to me, the outcome of this case rose and fall on this deferential standard. The court said all that's required for ballot language is that the clear and essential purpose of the amendment be fairly expressed without being misleading or unreasonable. And here it said the ballot language met that standard, and said that the district court had misread a 2012 case called League of Women Voters to reach the opposite result. The final case I want to talk about, I think, is especially interesting to lawyers because it's one of the few cases ever to talk about judicial conduct and to even dare to say a district court judge really acted inappropriately. So this is State versus Malone. It was a not a unanimous decision, a 5-2 decision with Justice Moore again as the author. The issue here was whether the district court judge's conduct during a pretrial proceeding called his impartiality into question and precluded him from presiding further in the case. And the court said it did. So let me tell you a little bit about what happened. We had a doctor charged with domestic assault. The chief judge of the district happened to be the presiding judge and issued a no contact order. And the doctor violated that no contact order, resulting in a new criminal charge. The morning of the trial over this charge, the doctor brings a motion to dismiss, saying the county can't prove he knew of this no contact order and saying he never got notice. So the presiding judge was very frustrated and said that the doctor wasn't being truthful. But then the judge did his own investigation into whether the doctor had in fact received notice. The judge communicated with the law clerk to verify how they normally send notices of no contact order. The law clerk then had communications with court administration to see whether the doctor's attorney had opened their e-service notification, and also suggested that court admin should call the county attorney and maybe suggest some possible witnesses for trial about the notice. So at that point, the defendant makes a motion to remove this judge who's presiding over the case, but has done this investigation about whether defendant received the notice. The judge refused, and the assistant chief judge denied that motion. The trial went forward and found the defendant guilty of violating that no contact order, and the defendant appealed. So the issue on appeal really was about Rule 2.11 of the Minnesota Code of Judicial Conduct, which says a judge shall disqualify him or herself in any proceeding in which their impartiality might reasonably be questioned. And so that was the primary issue here. The court cited a 1950 case saying judges shouldn't act as counsel for either party to the litigation and should always avoid the appearance of impropriety. And here, the majority said that the judge's conduct would lead a reasonable examiner to question the judge's impartiality. And so the judge should have disqualified himself. So again, just a summary of the facts leading to that are on this slide. But importantly, the majority said it wasn't actual bias in violation of a constitutional guarantee, because that would have led to other potential remedies. But the court reversed for a new trial due to the risk of undermining the public's confidence in the judiciary. Justice McHagan and Chief Justice Khalil dissented, mostly because they thought a new trial was not required. Just want to note on this one that I think Justice Moore is the right justice to have delivered this message, since he was a trial court judge for a long time and was a trial court judge outside the Twin Cities Metro, which is where this case arose as well. And so hopefully really has credibility with those 267 trial court judges, and can properly deliver this careful message about the code of conduct. So with that, we have like 2 minutes left. And so I'm looking at the chat and I see something about this case. Okay. In Malone, could the district court judge have done the same thing in open court sua sponte? So here I will say that a lot of what the district court judge did was in open court and in front of both parties, and that didn't seem to resolve the issue in the opinion of our Supreme Court, or at least this majority, but good question. And I don't, and then there's a question about whether any real estate cases of note. I do not recall any major real estate cases off the top of my head, but I don't have a list of the 81 in front of me. I'll invite my co-presenters to unmute if they're aware of any. Hearing none, thanks to all of you for being here with us. We hope you learned something about what the Minnesota Supreme Court is up to, and maybe even some cases that are important to your area of practice. And if you have questions about anything, our emails are on the screen. Have a great afternoon.
Thank you everyone for attending.